Steve is a trial lawyer who is in charge of Gibbons' Philadelphia office, and he concentrates on product liability, drug and medical device cases. He's here to discuss the preemption of claims against generics, how it's affecting the product liability lawsuits. I'll give you Steve.
Good morning. I agree with Greg Marshall, the previous speaker, that product liability law is generally not that difficult to comprehend, relatively simple to other areas of law, except when it isn't. And this may be one of those situations. I've titled this, the slideshow, Desperately Seeking a Solution, which is a weak reference to an old Madonna movie, and also a description of what the plaintiffs in pharmaceutical litigation are pursuing as they attempt to deal with a Supreme Court decision that came down a year ago, preempting failure to warn lawsuits against manufacturers of generic products. The fallout from that decision, which is the Mensing decision, is that the plaintiffs are seeking a way to get recoveries for their plaintiffs who were allegedly injured by using generic products, and are attempting to contort some long-standing rules of product liability in order to do so. The noted author, William Gaddis, once wrote that you get justice in the next world. In this world, you get the law. The implicit recognition in that quotation that the law may not be able to solve all problems comes into play here as we engage a difficult situation in which people are struggling with how to deal with the disparity in treatment between people who use brand name prescription drugs and people who are allegedly injured because of the use of the generic alternative. And frankly, there are a lot of unhappy people out there right now. Certainly the plaintiffs and their lawyers who represent users of generic products aren't very happy. The brand name pharmaceutical companies aren't very happy because now the attorneys are trying to hold them responsible for products they didn't make or sell. And frankly, despite the euphoria of the victory after the Mensing decision, the generic companies find themselves still engaged in attempts to bring alternative, different theories of liability to get around the Mensing decision. So let's see how we got to this situation. In 2009, the Supreme Court decided the Wyeth versus Levine case, in which the court held that federal preemption did not bar failure to warn claims against brand name pharmaceutical manufacturers. The Levine case involved the drug Phenergan, which is an anti-nausea drug, and came out of the District of Vermont, where a large verdict had been returned in the plaintiff's favor. And the Supreme Court weighed the arguments from the parties regarding whether the Food, Drug, and Cosmetic Act's provisions and the regulatory scheme that resulted from that act essentially co-opted the field in terms of what the warnings that could be on a product were. And the Supreme Court determined that that regulatory scheme did not preempt failure to warn claims against pharmaceutical companies. And the key point of that decision, or one of the key bases of the decision, was even though the drug companies have a rigorous regulatory scheme to go through in order to get approval for a drug and its labeling, they did have a provision, there was a provision that allowed those companies to unilaterally change the label in the event they had information that a particular side effect might be caused by use of the drug. That decision was monumental in the sense that it did keep the door open for thousands of failure to warn claims against pharmaceutical companies. And frankly, pharmaceutical companies, when they get sued in product liability, in a very high percentage, the claims are based on failure to warn. So we jump 2 years ahead to the mensing case. And the generic manufacturers come to the Supreme Court, and actually this was an appeal from 2 different cases, one in the Fifth Circuit, one in the Eighth Circuit, both of which held that claims against generics were not preempted. And the generic companies argued to the Supreme Court that Levine doesn't apply to us because under the 1984 Hatch-Waxman amendments to the Food, Drug, and Cosmetic Act, we are prohibited from altering the label that has been approved in response to the regulatory process initiated by the pharmaceutical company. And they describe how their business is creating products that are the bioequivalent of already approved pharmaceuticals. And part of the approval process for the generics is that they must have the same labeling as the original brand pharmaceutical company. So they make a very different argument to the Supreme Court. And they argue that, for example, that we cannot issue letters to prescribing doctors with supplemental information as the brand name pharmaceutical companies can. The respondents argue that there's no congressional intent to preempt state law tort claims against generic manufacturers. Preemption can be express, which is when Congress puts in the legislation, we are expressly preempting any state law claims as a result of this legislation, or implied, which is where the presence and the activity of the federal government in a particular area is so prevalent that the court can imply congressional intent to preempt this field. And congressional intent is the touchstone of preemption analysis. And the plaintiffs in the mensing case argue that the generic manufacturers have failed to demonstrate that the FDA would have rejected stronger warnings, a burden that they should bear when asserting federal preemption. The mensing court reversed the Fifth and Eighth Circuits in an opinion by Justice Thomas, joined by Justice Roberts, Alito, Scalia, and Kennedy. And essentially, they accepted the generics argument that they cannot change the regulations unilaterally, and that this was a conflict between federal law and state law, so that state law failure to warn claims could not be brought against manufacturers of generic products because, frankly, the generics don't have the ability to change the labeling. The dissent by Justice Sotomayor argued that just the possibility of impossibility was not enough to establish preemption, and also argued that there were things that the generics could do in order to make changes to the label. But they all involved going to the FDA for something and doing something, and someone else always had to have some role in whatever was being proposed. The decision hinged on the fact that the generics cannot unilaterally change the label. Now, this provoked a fair amount of angst, both in the court and without, because now we have 2 classes of consumers, one of whom has a remedy in a failure to warn case, and one group which does not. Justice Thomas was not blind to the situation that was being created and stated that we understand that from the perspective of Mensing and Demahy, the plaintiffs, finding preemption here but not in Wyeth makes little sense. We acknowledge the unfortunate hand that federal drug regulation has dealt Mensing, Demahy, and others similarly situated. Justice Sotomayor was disturbed by the result, might be one way to say it. She finds it absurd that this could be the result of the court's decision. And that it states that now, whether an injured individual, allegedly injured by a drug, has any remedy depends on the happenstance of what happened at the pharmacy when a prescription was filled. So the plaintiffs have now sought to get around the Mensing decision, and one way they've done it is with a theory called innovator liability. I don't like the term. Remember when innovation used to be a good thing? Now it's a prescription for liability. The plaintiffs are arguing that because the brand name companies knew that prescriptions would be filled with generic products, knew that consumers would be harmed, and took no steps to inform the medical community of earlier misrepresentations about metoclopramide, which is a drug Reglan, which was the subject of the Mensing decision, that they should be liable in fraud and misrepresentation. Innovator liability has its origin in a decision from the California Appeals Court, Conte versus Wyeth, frequently referred to as Conte. There's the Conte theory, which is that a brand name drug manufacturer owes a duty of due care when providing product warnings, and this duty extends not only to consumers of its products, but to consumers of generic products. It was followed by a district court in Vermont in 2010. The good news is that Conte is a minority view. There's a decision from the Fourth Circuit, Foster, which many courts cite when rejecting the Conte theory. So although there's a warning light here, because of the Mensing decision, a lot of the Conte theory is now being argued with renewed vigor in state courts. So although so far Conte has been accepted by only a small minority of courts, the battles are still going on. Seeking a solution, the next tact is, well, let's figure out another way, apart from a product liability failure to warn claim, to hold the generics liable for their products. The plaintiffs have come up with what they call failure to communicate claims, one of which is a failure to update claim. In other words, when a generic company allegedly failed to update a label after an FDA-approved change to the brand labeling occurred. And this has been accepted by a couple of courts. Also, a failure to send a Dear Doctor letter when the generic has not sent such a letter advising of changes to the brand label. This theory has been accepted at the pleading stage by several courts. But once again, the battles are still being waged at the present time. Plaintiffs have also attempted to convert failure to warn claims into fraud and misrepresentation claims and breach of warranty claims. And the battle here is whether what they're really doing is cloaking a failure to warn claim with a different coat, a different label. And with respect to fraud and misrepresentation and warranty, for the most part, the courts have come down on the fact that you can't get around Mensing this easily. These are, at their essence, failure to warn claims. Another possible solution, legislation. Democrat Patrick Leahy of Vermont introduced a bill in April called the Patient Safety and Generic Labeling Improvement Act, which was a bill to allow manufacturers of generic drugs to provide additional warnings with respect to those drugs in the same manner that the FDA allows brand names to do so. Sounds like a solution, but consider some of the practicalities. Now we might have multiple companies applying to the FDA for labeling changes. And the one thing that I think everyone would agree on is that we don't want different labeling on the same drug depending on who you're buying it from. The one thing that the current system has for it is that the label on the brand and the generic is going to be the same, and that is a desirable goal. we don't want different labeling on generic Reglan versus brand name Reglan. This is the New York Times from April 18th, 2012, a story about Senator Leahy's bill. And I don't really have a handle on whether the bill has a chance for success. I suspect it will meet heavy opposition, especially in the House. But the generic drug companies, I think, make a good point when they say that this would create a chaotic situation in which several different drug companies could publish conflicting information about the same drugs. So, in concluding, when we're seeking a solution for an apparent disparity in treatment between one class of consumers and the other, I would recommend that the solution does not lie in contorting product liability law so that people can be, or companies can be held responsible and liable for another company's product. I read a case called Greenman versus Yuba Power Company in my week of law school, I think, in my torts class. That was the California decision that was a seminal decision in the evolution of product liability law. And one of the principles is that the defendant, as the manufacturer and or seller of the product, bears some responsibility for it. That is a touchstone of product liability law. You disturb that, and you create possible chaos throughout the field. The other point I would make is that just allowing plaintiffs to circumvent a decision by the highest court in the land by relabeling or redesignating what they call their claim, not a good choice. We have to pay more respect to the Supreme Court decision. Whether there's a legislative solution, I don't know, but the solution is not redoing product liability law. Thank you.